The opinions expressed by Peter Wexler, Robert Quittner, Kyle Plotkin, Michael Hart, Nicholas Hamner, and guests on this show are their own and do not reflect the opinions of this network. All statements and opinions expressed are based upon information considered reliable, although it should not be relied upon as such. Any statements or opinions are subject to change without notice. Investments involve risk and, unless otherwise stated, are not guaranteed. Past performance cannot be used as an indicator to determine future results. Any strategies mentioned may not be suitable for everyone. Information expressed does not take into account your specific situation or objectives and is not intended as recommendations appropriate for you. Before acting on any information mentioned, please consult with a qualified tax or investment advisor to determine if it is suitable for your specific situation. This program is designed to provide accurate and authoritative information with regard to the subjects covered. Investment advisory services offered through Brookstone Capital Management LLC, aka BCM, a registered investment advisor. BCM and Franklin Retirement Solutions are independent of each other. Insurance products and services are not offered through BCM but are offered and sold through individually licensed and appointed agents.
So we're going to talk about Phil and Connie today. It's a case study day. Phil and Connie are not real. They are both aged 58. I mean, they're not real in terms of they are not real people that this is based on. This is not us revealing somebody's financial information. This is a hypothetical scenario that simulates a lot of what we see in the office. So Phil and Connie, both aged 58. So that would make them early Gen X, I think. Are they really late boomer? 58 would be...
No, that'd be early. 58.
76? No, that would be 66. That is...
They're cuspers.
This is good pod.
Baby boomers were 65, right? That was when the baby boom generation ended? 1965?
I believe so.
So, yeah, they are early Gen X. They have 3 kids, 2 of which are trustworthy. Third child has bad spending habits, what we call the spendthrift child.
So he's the third child.
Yes. The baby.
Yeah.
Spoiled with
Spoil
everything.
rotten. Yeah.
That generation, let's see, they raised the first kid as the experiment. Second kid was completely forgotten about. Third kid could do no wrong.
It's interesting that often the first kid who's the experiment turns out the best, even though it's the parents' first attempt at everything.
Well, I feel like 85% of all jet skis are owned by third children.
That's probably a fair statistic.
I don't know the correlation there. I just figured jet ski equals irresponsible.
It's fair.
I would mention Harley Davidsons, but I don't think anybody in Gen X is going to own a Harley.
Nah.
That's a boomer thing. So let's talk about Phil and Connie's situation. They have a house. They own it jointly, and it is valued currently at $600,000, which means when they bought it, it was probably about $25,000. They have a second home in the mountains, valued at $325,000 currently, and it is not a timeshare, thankfully. That house is in Phil's name. They have a joint brokerage account with about $800,000 in it. Phil has an IRA with about $400,000. Connie, because she wasn't working a lot, she spent a lot of time raising the kids. Connie's IRA is only at $150,000. Then they have a joint checking account with about $60,000 in it, and Phil, and only Phil, has a universal life policy with valued at $850,000. Like it's going to pay out $850,000.
Death benefit $850.
Death benefit of $850,000. So that's what we're starting with, and what we're going to do is kind of see how Phil and Connie are going to age and what's going to happen with this money. That's our scenario for today. So buckle in. It's going to be super exciting. So we're going to start off. Oh, hit the wrong button. I did that whole intro without playing with the camera. So I'm in charge of the camera today. So if you notice any late lapses like now, that's because I have the keyboard. But let's go back to the group setting. So we're going to start things off with Phil having a heart attack. So Phil is incapacitated and he is unconscious. What options are there for somebody to make a decision on Phil? You guys know?
Well, the question becomes does Phil have, a healthcare power of attorney?
Well, yeah, there's a couple of options he could have in place. Go back to me. Yeah, this is going to be horrible. I'm just going to leave it in the middle. You guys don't get camera changes today. We're all looking at this camera right here. No camera changes today. It's too
Camera one.
complicated. 1, 2, 3. I can't do it. We're leaving it at 2. So you have to have some kind of authorized agent to make decisions for you if you're going to be incapacitated or if you feel you're going to be incapacitated. So you can have an advanced healthcare directive, what we often call a living will, just something, this could be as simple as a DNR. But at 58, I would hope you don't have a DNR in place for something that just knocks you unconscious like a heart attack. So most likely you're going to have some kind of power of attorney. You can have a specialized healthcare power of attorney. That is just there to allow someone to make healthcare decisions on your behalf. Usually it's just a HIPAA waiver. It's going to be very likely your spouse or a trusted child. But then that's the healthcare side of things. So an advanced directive or healthcare power of attorney.
Now, does the spouse have an automatic, the automatic decision making at that point?
That's going to vary state by state, and that can even vary hospital by hospital. So it's always better to have, it's the old engineering rule. Why should everything be written down? Why should everything be documented? Because a piece of paper is just big enough to cover your butt. A piece of paper is just big enough to cover your butt. We'll bleep that out so you can understand what we're saying without getting in trouble with anybody. So that is the healthcare side of things. But let's say Phil has a heart attack, they do the surgery, but there's a complication and he doesn't wake up. He is now in a coma. Who can make those decisions, the healthcare decisions for him with him incapacitated? And again, that's going to vary state by state. So the better idea is to have that document in place. So you can have a durable power of attorney. That's just effectively coming in and saying, here's this document. At any point, my spouse can make a decision for me in any matter. You can also have a springing power of attorney. That's you set a condition, and once that condition's reached, the power of attorney springs into action. There are also temporary power of attorneys. That's what you sign when you buy a car and you need somebody to file for the plates and tags for you and all that stuff. Mm-hmm. So that is the power of attorney situation. Now, Phil doesn't wake up. Phil ultimately passes away. Whether Connie decides to pull the plug, we don't have that information in this hypothetical. But Phil is now dead. What's going to happen to Phil's stuff? So just as a reminder, Phil and Connie own the house together. They own the vacation house is only in Phil's name. They have a joint brokerage account. Phil has the larger of the two IRAs. It's in his name, but let's assume there's beneficiaries. Connie has her IRA. They have that joint checking account, and Phil has the life insurance policy. So really, when we're talking about what happens to Phil, it's really going to depend on what he's got set up. So,
or what happens to Phil's stuff, more accurately.
So what's going to happen to his stuff? And this is where we really start talking about estate planning. And the good news is everybody has an estate plan.
That's right.
And that's the phone, so don't worry, I'll get that. No, it's a little graphic that just says, technical difficulties, please stand by, or something like that. I think I have the server on fire or something. So yeah, so we're talking about estate planning, and the good news is everybody has an estate plan. The bad news is if you haven't built it yourself, then your estate plan is the government's estate plan. And that's technically considered passing intestate without a testament. So if Phil had put together a will, we all know what a will is. We've seen the Hollywood version of it a million times. I, Phil, being of sound mind and body, do hereby declare blah, 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 blah. Most wills are nothing dramatic. It's always, to my loving wife, Helen, or in this case, Connie. To my wife, Connie, I leave everything. And so a will specify who gets your stuff, specifies an executor or an executrix. That's the person that's in charge of administering the estate. And then anything in the will has to be distributed via probate. We can talk forever about probate. I mean, you guys have probably seen the stuff. Is it a good thing to go through probate, or is it a bad thing to go to probate?
Generally, it's not good.
There's pros and cons to each, but in general, if you can avoid it, probably for the best.
So the advantages of probate, you said there's good parts about everything. The advantages to probate is that somebody with oversight ensuring that your wishes, that as you've specified them, are taken care of. It allows for protection because probate can limit the time that it can be challenged, and it limits how long creditors have to make claims. So it protects your stuff to some degree, and it provides the deceased some level of control. So Phil has some level of control if he had left a will. He did not. The disadvantages to probate. Any guesses?
Disadvantages to probate can be costly.
Yes.
It can take a lot of time.
Time is really not one of the major disadvantages. It does become an issue if the executor doesn't do a job or a family member doesn't agree and starts to challenge. Then probate can drag on for months or years, and if there's a law firm involved, well, the only person winning in this estate plan is the attorneys. There's also the transparency concern. You have no privacy with probate because it is a public process. It will be a matter of public record. Also, there's estate taxes. Some states even have an estate tax, but the federal tax plan is always there. And honestly, we can't really conjecture what would happen with estate taxes at any case because the estate tax exemption, when do those expire?
End of next year.
End of 2025.
Potentially. More than likely.
They were greatly expanded as part of the Trump tax cuts. They are set to expire December 31st of 2025. What it looks like for 2026 and beyond, we don't know. That's going to be Congress, and who knows what they're going to do.
At this point, the numbers get cut. What is it, half or 2/3?
I want to say 2/3. It's a dramatic cut. I mean, right now, if a couple passes away together, tragic plane crash or car wreck, they can pass on over $24 million without being subject to the estate tax, which if you have $24 million in assets between the two of you, I guarantee you're not watching this podcast. But if you are, please stand there nearby the nearest bush and pay no attention to the man in there with a sock full of pennies.
We'd love to talk to you.
Yes, we would love to talk to you in a dark alley. But yeah, so that doesn't really apply to anybody that's watching this. It really doesn't apply to a whole heck of a lot of people. It applies in general to less than 0.5% of the population. Some states have death tax. Pennsylvania is one of them. And again, it's such yes, estate taxes will apply. What those estate taxes will be, who can say? But
Well, it doesn't. It's rarely or if ever going to apply to the spouse.
right.
So the spouse can generally step in and basically assume the assets as if they were their own. In most cases.
Yeah.
And then there's generally not going to be an estate tax when it passes from one spouse to the other. And then with the states that have it, Pennsylvania is one, for example. If it goes to the kids, they're going to pay one rate. If it goes to, I believe, a sibling, they're going to pay another rate. And if it goes to anybody else, there's a third rate that they have to pay. And those are progressively higher as you get further away in terms of the familial relation.
So the question then becomes, is there anything better than a will that avoids probate, that allows for the same control as a will, but also gets a handle on the tax situation?
Could it be a trust?
It's like you're following along in the notes, Mike. Yeah, so there's a lot of trusts. I mean, if you really look at any kind of directory of trusts, there's 20 plus different types of trusts just commonly mentioned. But to focus on what we're focusing on today, which is what would happen with Phil, what would happen with this average family, what are some things they could do? We're going to talk about revocable trusts and irrevocable trusts. Now, both of these are created while the person is still alive. You can't create a type of trust after they're dead. These are living trusts. And in Latin, who knows what they're called? Living. In life. Inter vivos.
Oh yeah, inter vivos. Yep.
Lawyers love Latin until you actually make them speak it, and then none of them say it the same way. So we're talking about a revocable trust, which by definition is not set in stone. It can be revoked. It can be revoked at any time. Income tax is pretty simple to report. Assets receive a step up in basis, which is always good for taxes. You can have the settlor serve as the trustee and the beneficiary, which is one person in all three roles. Now, in a trust, if you're unfamiliar with trusts are legal documents. They're essentially safes on paper. You put trusts away, you put your assets away in this trust. There's a second party that directs control of the trust, and the third party is the beneficiaries. So every trust is going to have three parties at minimum. In a revocable trust situation, you can actually have one person in all three roles. Probably not recommended unless you have a lot of money and time to designate to this. A revocable trust can actually work while a person is incapacitated as well. And as we discussed last step, this is a good thing. If it's set up and funded correctly, a revocable trust can avoid probate. So your business stays your private business. Downsides, you guys aren't even looking. Might not avoid estate tax, so it doesn't really work on that side of things, and it does not protect from creditors, predators, and the IRS. Now, if we move over to an irrevocable trust, what do we have? Irrevocable trust, what makes them different from a revocable trust?
It can't be changed.
Cannot be changed. But they can be the assets within an irrevocable trust can be transferred free of estate tax, which is always good. Settlor, again, can serve multiple roles. You do gain the asset protection from creditors and predators and the IRS.
But you lose control.
You do. So you have to know what you're doing at the start and make sure it's what you want done the whole time. So that is trusts, but not really. Well, actually, yeah, I'm not gonna cover this stuff because you have to have a fiduciary that's in charge of the trust. They are the trustees. There's a cost-benefit analysis here. There's a risk and benefit. There's a risk-reward, however you want to label it. There are professional fiduciaries. Basically, you can appoint an attorney to be in charge of a trust. How much is that going to cost? A lot. Or you can appoint anyone else to be a trustee. You can appoint your uncle, your cousin, a sister, a spouse. But they don't have the professional level of quality to make sure everything's done correctly. So it is a risk-reward, cost-benefit analysis you have to do. It's not anything we can really discuss and give a proper opinion here. It's just something you have to consider and weigh the benefits of.
Yeah, I mean, generally that's something that that's one of the reasons why you would hire an attorney to help you with this stuff, is to help you with those kinds of decisions.
So I'd mentioned attorneys being good with Latin, or at least liking to use Latin. And one thing when we talk about beneficiaries and heirs and any kind of estate plan, two phrases: per capita, per stirpes. Who knows what either one of those means?
Per capita is by the head, per stirpes is by the branch.
That's effectively how they function.
I believe the technical translation is by the roots, isn't it?
Well, I don't. Per capita is by total number of individuals. Per stirpes is by representation. So I think Kyle had it best.
Per capita capita is the head. That's why
Yes.
we call a hat a cap.
But it is also, the way it functions in practice is per capita. If assets are distributed per capita, they are only going to apply to the living heirs. So, man, let's say we've talked about Phil having 3 kids. All 3 of those kids are alive, so it doesn't really apply here because all 3 of those kids would get a 33% share split that way, split per capita. But if one of those kids is dead and they have grandchildren, if they have children that would be Phil's grandchildren, those grandkids would receive nothing because that child is deceased and would not be a part of a per capita distribution. But if they're distributed per stirpes, you have 3 kids, the one deceased kid has 3 kids of their own, meaning they're 3 grandkids of Phil. Each branch of the family would receive 33%. So the 2 living children of Phil would get 33% each. The 3 living grandchildren of the deceased child would receive 11.1% because it would be distributed evenly. That is the difference between per capita and per stirpes. That is something that that usually gets glossed over. It's just a checkbox you have to check depending on what you're filling out. Not a lot of people pay attention, but it can have lasting consequences. So pay attention when we're talking per capita and per stirpes.
It is very important, and it just as an example for here in what we do in our practice, that is a conversation that we generally do have when setting beneficiaries.
Mm-hmm.
So one thing we haven't discussed, we discussed what would pass in a will, what would pass in a trust, but there was the joint investment account of $800,000. How does that pass? If it's jointly held, what happens when Phil passes away?
It goes to the
Yeah,
other
go to the
joint
wife.
owner,
Right.
the surviving spouse,
The home that was owned jointly,
surviving spouse.
depending on the terms of the deed, but yes,
I mean,
very
as long,
most likely.
consider it as long as it was owned by a husband and wife. If it
Yes.
was owned by like somebody and then one of their kids, different story.
Phil's IRA valued at $400.
Depends on the
Yeah,
beneficiaries.
whoever the
So
beneficiary
how
is.
do IRAs and life insurance pass?
So IRAs and then any life insurance product, so annuities work this way also, is they are going to go, they do not go according to the will.
Right.
They will go according to the beneficiary forms. So those are extremely important. Usually it's something you don't even think about. And we've done previous segments on this where somebody had a 401k they opened up in 1987 when they got their first job. They put their, say their girlfriend at the time as the beneficiary. They broke up a year later. They never changed it. Now it's 2024. There's $1 million in that account.
we-
They die. It's going to go to that girlfriend from 1987.
We did cover that in a previous show. The man had done exactly that. Created a 401k beneficiary form when he got his first job back in the 80s. Had his girlfriend at the time on there. He subsequently gets married, has children, dies. This girlfriend is amicable when she finds out what happened, but she was set to inherit over $1 million. Didn't want it, wanted it to go to his family, wanted it to go to his brothers and his kids, and there was no legal way to get out of it without her taking it, paying the taxes on it, and then distributing what was left. But yeah, so we're talking beneficiary, tongue-tied. We're talking beneficiary forms. These are another one, like per stirpes, per capita.
Yep.
You fill it out real quick. You don't pay attention to it. A lot of them allow you to set primary and secondary beneficiaries. Some of them even let you set tertiary beneficiaries.
Some of them will have a checkbox for per stirpes.
Mhm.
Sometimes some of them won't, so you have to actually write it in.
Yeah.
There's all kinds of different ways that they can go in or on the books, but regardless, that's how the money's going to go in any kind of qualified account, so IRA, 401k, 403b, or any type of insurance product, whether it's a life insurance policy or an annuity.
So I have a question. Would you rather get in a taxi that you can't control where they go? It's taking you somewhere, but you don't know where. Or would you rather not get a cab at all?
Well, I guess this depends on like how much I've had to drink at the time. But if we're being serious, obviously, you want to know where you're going.
Right. And that's really where we are with beneficiary forms. If you don't keep up to speed with them, your money's going where you don't want it to go.
Yep.
And if you don't fill them out, your money's going to go where you don't want it to go.
Well, if you don't fill them out, where's your money going to go? If there is no beneficiary file, or there is no beneficiary form on file, that's also a problem because then where does the money go?
And where does the money go?
The money then has to go into the estate, which is going to go through probate. And that really becomes a problem in something like a qualified account where there are going to be income taxes attached to it. So in a case where somebody inherits an IRA account, generally they're going to take that as an inherited IRA. So, and that's usually what's advisable because otherwise you got to pay all those income taxes the year that you inherit it.
Yep. It's not.
Well,
it's never better to not have a plan in place.
Right, because if you don't have, let's say you don't have a beneficiary in place on a 401k. If you, at that point you die, it's going, there's nowhere specified where it's going to go. So it has to go into the estate. Once that happens, it becomes fully taxable because that's all going to be income for somebody. So if there's $1 million 401k with no beneficiary forms, even if it's going to go to your only kid, that's going to force your only kid to take that $1 million as income in the year you died.
Yep.
So what's the golden rule? How often should you be checking your beneficiary forms? How often should you be looking at your will?
I would say, well, I mean, I'm sure there's a golden rule in terms of time, but really also anytime you have a major life change is when you want to consider, looking at those documents and see if anything needs to be changed. Other than that, it was 3 to 5 years.
Usually 4 to 5. I mean, it's in general. Think about where your life was 5 years ago. Think about who your friends were. Think about how your family was structured, how your relationships were 5 years ago versus now. Especially if you do have children under the age of 18. Are the people you were friends with 5 years ago and likely have specified as a guardian in some guardian? Are the people you have specified as a guardian 5 years ago still the people you want looking after your kids? It's tricky.
Maybe not.
I mean, I'm trying to think, what's the idiot rule? Was 10 years? What? 10 years is all it takes to look back on a decision you made and say, I was an idiot?
Doesn't take 10 years.
Well, I mean, usually that's a good guideline for a tattoo. If you wouldn't look at it 10 years from now and say, what was I thinking? Then it's okay. But think about how your brain changed. Look at the decision you made 10 years ago versus now.
What are you trying to say?
I'm saying probably all of us have a ridiculous tattoo somewhere.
I got no shame.
Yeah, just look at A.J. McCarron and his giant chess piece that he got in college. He started it in high school, kept it through college, and I can't imagine what he looks like now.
Well, if you got like a SpongeBob tattoo on your ankle, let's just say.
I feel like cartoon characters are the worst. That's like naming your kid after a TV show character.
I knew a guy that had Mighty Mouse on his calf.
It's kind of an odd place to have Mighty Mouse.
He was kind of an odd guy.
Yeah. I knew a guy that was legitimately covered in tattoos. They were all scratch tattoos. Just because he had friends who were tattoo artists and were like, do you mind? We need skin to test on. He's like, go ahead.
Yeah, so he was just like a practice dummy.
He also had several health conditions that were genetic, and he had a horrible lifestyle. So I don't think he planned to be around long. And truth be told, I don't think he is still around.
But his body looked like scratch paper.
Yeah. I forget what the explicit phrase. He had a duck shouting, but he had a duck on his elbow screaming some kind of horrible phrase. He was a chef. I think when you have somebody that's a professional chef, you just assume questionable lifestyle decisions.
Generally.
Yeah.
Unless you're like, the high-end chef, different story. You went to school for it.
The fine dining.
So what happened to Phil's stuff?
So, if Phil had no will, everything passed intestate, all the joint assets went to his wife, Connie. His IRAs and life insurance went to the beneficiary form, the parties named on the beneficiary form. His assets must pass through probate. The state's intestate rules apply. There's very likely going to be a fight over control by the family. Assets will pass to children, regardless of preference, and to the creditors, but the creditors are going to get first bite. And I mention kids because, I mean, more and more we see families falling out with their kids, and there could be kids that Phil did not wish to gain a portion of his estate, but they did. Overall, you're going to see fees and costs probably eat away 5 to 8% of the estate.
About the spendthrift kid.
Well, I mean, he's going to burn through that anyway. You know the average time it takes for someone to buy a new car after inheriting money?
It's not long.
19 days. So no matter what you leave your kids with, just know within 3 weeks' time of them getting that money, that's a new Toyota in the driveway.
And they're going to fly first class to that vacation that they book.
I don't know. Depends on how much money you leave them, and depends on where they're going. But now let's assume Phil played it safe and had a will, at least a will. Even if it was like a $75 internet will, which don't ever do the $75 internet will. Those things they're landmines. So if he had a will, the joint assets would still pass to Connie. His retirement assets, all those IRAs and stuff, would pass through the beneficiaries. The assets are still going through probate, but Phil will at least control who's overseeing the estate and the executor. His wishes will be there, determining who gets what, how, and when. So that spendthrift kid might not get that money for 10 years. Might allow him some time to get responsible. And he may have some kind of asset protection in there for his loved ones, but probably not. And again, the fees and costs are going to be in that 5 to 8% ratio. So that's going to take a big chunk off. But if Phil had played it smart, talked to an attorney a lot, realized that his estate was of the size and diversity that a trust would benefit the family, the trust would be formed to control everything, who got what, who was in charge of what. His retirement assets would pass to his beneficiaries or the trust, because the trust would hold the property. It avoids probate if that trust is funded. The trust would designate who gets what and how they get it.
So it would handle that spendthrift kid.
Yeah. Meanwhile, everybody involved would have super clear instructions, because a trust is usually much more verbose than even a complex will, which minimizes the conflict, minimizes the chance of it being challenged, and the trust can provide additional protection from the creditors, the predators, and Uncle Sam, which is always good. And the best part is your fees and costs are around 2%. So it's costlier at the start, but it pays off in the end if you want to do a trust. And of course, if that works for one part to a party, it's going to work for the spouse as well. The estate planning would need to be comprehensive for both. And that is really the story of Phil and Connie and how they lived and how they set their things up, and really the dangers you need to watch out for. If you have any questions and comments, we've got the banner up, info@franklinrs.com. Give us a call at 215-657-9200. That's going to be our show today. We'll see you again next week. Have a good weekend.